law, areas of work coverage. So winding up of a company. Now, what do you mean by winding up of a company? Winding up of a company. Remember, we have done the discussion on introduction of the company law, the formation of a company, the types of a company. Then we moved to the doctrines of a company. Then we did the organic theory of a company. Then today we are coming to winding up of a company. Welcome. Winding up of a company, introduction. The Companies Act, CAP 486, does not define the term winding up or liquidation, but it uses them interchangeably. So the word winding up or liquidation mean the same thing. It is a process of putting an end to the life of a company. Remember, when you're registering a company, we say a company is coming to existence. So when the company is coming to an end, we say winding up. Now, comparing to partnership, in partnership we talk about dissolution, but in company we talk about winding up. A company is dissolved and its assets disposed and its debts are paid. So it is a requirement. In the time of winding up of a company, assets are disposed and debts are paid. The excess is distributed among the members in accordance with their right. So whatever remains after disposing of the assets, after paying off the debts, then the excess amount remaining is shared among partners according to their laws. Methods of winding up. 1. Compulsory winding up. 2. Voluntary winding up, which it can be by members or by creditors. Then finally 3. Under the supervision of the code. Takes place when the company is ordered by the code to wind up, section 2019. So compulsory winding up normally takes place when the company has been ordered by the court to wind up, to close down the shop. This occurs in the following circumstances. So what causes winding up, compulsory winding up? Number 1, special resolution of the company. So when the company comes together, when the shareholders comes together, they can make a resolution for winding up the company. So by special resolution, resolve that it may be won by the court. Power of the court is discretionary. The court may refuse to order winding up where it is opposed to the public or company interest. Default in holding statutory meeting or delivering the statutory report to the registrar. So when the company fails to actually submit their statutory meeting to the registrar of companies within a period of 14 days, then the court has the authority to declare that company dissolved. Number 3, failure to commence or suspension of business. Now, if a company has been registered, when the company does not commence its business within 1 year from its incorporation or suspends its business for a whole year. So this is a case whereby a company has been registered and the requirement is that the company must commence its business immediately. Now, if the company fails to commence business, it is required to do a suspension letter to the registrar of companies. So when the company fails to do this within a period of 1 year, that company is declared dissolved or compulsory winding up. So these are the cases which cause compulsory winding up. We have a case here of Orissa Track and Enamel Works Limited, 1973. A company business remained suspended for 10 years. Its capital had been embezzled. Its major contributors, the Orissa government, refused further help. It was held that the company should wind up. So it's a case in dissolution, failure to start the company. 4. Reduction of members. When the membership, in case of the private company, below 2 members and public company below 7 members. Inability to pay debts. So if a company is not in good position to pay its debts, it has to be dissolved. And 6. Just and equitable. This is when the court of the opinion that it is just and equitable that the company should be wound up. So the court can issue a rule which is just and equitable. Now, what causes just and equitable of the company to be? Order on just and equitable. 1. Where there is deadlock in management. So when the management are not agreeing on anything, then it is required to be winded up. Where it is impossible to carry on the business of the company except at loss. So when the company is running at a loss, where the company has engaged in illegal business. So if the company is engaging in illegal business, it must be just and equitable to be wound up. Where the object for which the company is formed is impossible or further pursue. Where the minority is being disregarded or oppressed. Where there is lack of confidence in directors. Where the company has been conceived or brought forth in brawl. Compulsory winding up may be petitioned by who? 1. The company. A company may itself file a petition for winding up after it has passed a special resolution. Creditors. Every person having a peculiar claim against the company, whether actual or contingent, and such person is competent to file a petition for the winding up of the company. Dispute debt. Creditors whose debt is disputed cannot get a wind up order. So these are cases whereby winding up can be petitioned. Petitioned by any contributory. Section 214 defines contributory as any person liable to contribute to the assets of the company in the event of its being wound up. It, however, includes all persons who at date are members of the company or have been members within a year immediately preceding that date by officials. So officials can declare the winding up petition by Attorney General in consequences of reports of inspector upon the company affairs. So these are people of the authority to petition to stop the winding up process. Voluntary winding up. Volunteering to wind up. 1. It is the winding up by members or creditors without interference by court. A company may wind up voluntarily when 1. The period fixed by the article for the duration of the company has expired, or an event upon which the company is to be wound up has happened and the company in general meeting has passed an ordinary resolution. If the company for whatever reason has passed a special resolution to wind up voluntary, members voluntary winding up. If declaration of its insolvency is made, its members voluntary winding up. The declaration shall be made by majority of directors at the meeting of the board that they have made a full inquiry into the affairs of the company, and that having done so, they are of the opinion that the company has no debts, that it will be able to pay debts in full within 12 months from the date of commencement of the winding up. So this is a case whereby members volunteering winding up. 2. Creditors volunteering winding up. Voluntary winding up, where the declaration of insolvency is not made, the winding up is referred to as creditors winding up. It is presumed that the company is insolvent. In such a case, a company must call a meeting of creditors on the same day or the following day after the meeting, at which resolution for winding up is to be made and proposed. So this is a case whereby creditors are giving a notice that the winding up must be undertaken, and the reason being the company is insolvent. The directors must lay before the creditors the position of the company. Winding up subject to the supervision of the court. Section 304 provides that when a company has passed a resolution to wind up, the court may order the continuation of voluntary winding up subject to their supervision on end terms. The liquidation will continue to exercise all powers subject to restriction laid down by the courts. If there is substantial dispute between the company and creditors, especially where they disagree over the appointment of liquidators, so this when court now declares the liquidation, distinction between voluntary winding up and compulsory winding up. Declaration of solvency is a must in members where it's not necessary in creditors winding up. So declaration must be done of insolvency if it is voluntary. Mode of discharging liabilities in case of winding up. The company must pay all costs, charges and expenses, property incurred in the winding up, including liquidation costs. These expenses run in priority to their claims. Preferential creditors must be paid under Section 311. The following preferential creditors must be paid in priority. All government and local rates payable within 12 months before the date of winding up. 2. All government rent not more than 1 year. Wages and salaries of the servants for service rendered during 4-month preceding relevant period not exceeding 4,000. All amount due in respect of any compensation under workmen's compensation which has occurred before the relevant date. Finally, proceeds left may be given to shareholders, and if any portion remain unclaimed, it goes to the public trustee as bona vacantia, that is ownerless property. So that's how winding up takes place. Thanks for winding up successfully.